All right, welcome to the Colorado Real Estate Exam Prep. And today we're going to talk about two subjects. And those two subjects are going to be requirements governing the activities of licensees and brokerage relationships. All right, cool. So this is 22 items on your exam. So what you're staring at right now is directly from PSI. This is the brand new candidate bulletin that says, like, this is what they're going to test you on. So out of these two subjects, again, there's going to be 11 questions around requirements governing the activities of licensees. And there's going to be 11 questions around brokerage relationships. So we're talking 22 questions. And so let's think about a T-bar graph, right? We got the part divided by the whole. 22 divided by 74, that's almost 30%. This is almost 30% of your state quiz is going to be just these two sections right here. So these are two very big sections. We're going to go through, advertising, trade names, brokerage administration, handling the documents, listings, practice of law / seller financing. That's a hot topic in 2024 with interest rates and everything going on. And then brokerage relationships. We're going to be looking up disclosures, transaction brokerage, single agent, designated broker. And so we're going to go section by section. I'm just going to call out big pieces. And today is going to be more of really just kind of cleaning up the subjects for everybody. So let's start this thing off and let's talk about advertising and trade names. So first and foremost, no broker shall advertise in a way that would mislead the public concerning the identity of the broker or firm, right? So we have to keep in mind that the Colorado Real Estate Commission is in place to protect the people, the public, from us real estate agents. And so when we're going out there and we're advertising, we have to let them know what brokerage we're a part of and what our name is. And the best way that I remember this is, like, if there's an issue where the CREC, the Colorado Real Estate Commission, needs to send out a fine, they need to know where to send the fine to. So they know your broker and your name, right? So the second thing is trademarks. A brokerage firm may use a trademark as long as this is with the legal name or trade name and they have permission from the owner of that trademark. All right, cool. So when we're talking about this, for example, I am the team leader for Keller Williams Avenues Realty. And so that's a trademark, right? Keller Williams. The brokerage firm has a different name, but we trademark as Keller Williams Avenues Realty. Keller Williams is definitely a trademarked company, a trademarked brokerage. And so we can do business under trademarks as long as we have permission to do so. Here's one, and it's teams. The biggest thing that we're thinking about when we're going through here with your team name, it can't have realty, real estate, realtor, company, corporation, corp, Inc., LLC, LP, or LLP. And the reason why, as we're going through and we're looking at this, is because we don't want the public to believe that we're something bigger than we truly are. Like, that's the only reason why this is the way that it is. They don't want us to mislead the public, to make the public look that we are a bigger entity than we truly are. So I do operate, I think we can see it up here, Absolute Home Group. And so that is my production business. And my production business, that's a perfectly legal trade group name that I'm allowed to use. We're not allowed to use realtor because realtor is a trademark, and it's when you're a part of the NAR, right? So the National Association of Realtors has realtors as the designation. And so we can't use realtor anywhere in our name as well. Then we're going through and digital marketing. And I think you might see a test question around digital marketing. And the biggest thing to keep in mind is just that every page, we just have to be a click away from your name as well as the firm. All right. So your name and the firm have to be on your digital marketing somewhere. So we're talking about websites. In all reality, this is a website thing. There's different rules when we're talking about social media posts. I don't think you're gonna get a quiz question around a social media post, but really the social media post is that it has to be, if there's not enough space for it, then it has to be a click away, is really what the rule is. yet when we're talking about web pages, which is I think where you're going to see your test question, if you do get one around this subject, it just needs to have broker's name and the firm. So your name and the firm need to be associated with somewhere on that page. Because keep in mind, guys, when we're going through this quiz, this exam with PSI, that you are an associate broker in the state of Colorado. So when we're lining up this quiz, you're going to do the national side first, right? So you're going to do the national exam. And in the national exam, they're going to talk about salespeople. They're going to do all kinds of stuff because they're just trying to capture the whole population. But when we move into the state side of things, we're an associate broker. So we have to be able to know context clues as we're reading through this. Are they talking about our supervising broker, our managing broker, or are they talking about us, the broker? So this is you, the broker, and the name of the firm. The next thing is broker administration. So specifically, we're going to be talking about office policies. So the manual requires for all employing brokers or the employing broker's brokerage firm, which contains certain policies and procedures. All right, so you're joining a brokerage, and the brokerage has to have an office policy. This is the playground rules. This is going to say how you can help the public. Can you help the public as an agent inside your brokerage? Can you help the public as a transaction broker? Can you help a customer? It's going to lay out confidential information, what you're allowed to do at sales meetings, how you're going to use the printer, like all those different things are going to be outlined in the office policy. Now, for test question purpose sake, only multiple person firms have office policies. So if you're an independent by yourself, right, you had your 2 years of supervision, you're like, I want to go out on my own. And you go to your own brokerage, ABC Realty, and you start this thing up, and you were the sole person at this brokerage, you do not need to have an office policy. All right. And every independent broker or employing broker residing in Colorado must maintain a place of business in this state. And it says, except for associate brokers or brokers registered as inactive. All right, cool. So here we go. What this is saying is this: your employing broker / the brokerage firm, right? Because independent broker, single party, employing broker, they have to have a place of business. All right. And I go back to thinking about the name and where the brokerage firm is because they need to send the fine. Well, here it is. They need to know where to knock the door if they want to go hand deliver that fine to somebody. That's where my mind goes every time I'm looking at this thing. It helps me remember, like, again, everything's to protect the public. And if there's any investigations or any other issues, they need to know who to go to and where to go. So you, the associate broker, can live anywhere. You can have as many licenses as you want. You could be licensed in all 50 states if you wanted to be. Sounds like a lot of work, yet you could. And so when we're thinking about this isn't you, the broker, need to reside in Colorado. It's your managing broker needs to have a physical address in the state of Colorado. When we're talking about rebates, referrals, fees, inducements, and settlement service providers, first and foremost, a broker representing a seller in a transaction may rebate a portion of the commission to the seller. All right, so you're allowed to give money from your commission back to the seller. That's just rebating the compensation. That's perfectly legal. You can say, hey, Mr. and Mrs. Seller, if you use me, I will give you a percentage of my compensation back. And there's incentives for them to do that because it can help towards some closing costs. You can do that with the buyer as well. You can do it on both sides. The payment to the buyer and the advertising of the inducement is not in violation of licensing law or RESPA. So you can do this. Perfectly legal to give a part of your compensation back to the seller or the buyer, even if they're not licensed. Perfectly legal because it's part of the transaction. It's going to go on the settlement statement, right? We know that anytime there's money moving around RESPA and TILA, that we actually have to have it on the 6 column worksheet, the closing worksheet. All that information has to be on there, because if it's not on there, then we are in violation. It's probably loan fraud and some other things, which could lose our license, maybe even put us in jail. And we no one wants to go to jail. RESPA prohibits settlement service providers from giving or receiving any things of value to another settlement service provider for the referral of business when the transaction involves a federally related residential mortgage. All right. So when we're talking about this, I really just think of like maybe my title company, right? The title company cannot say, thank you for using me, agent. Here is this. They can't do that. They have very, very strict rules and regulation around how they're allowed to market to us. I think their current rules like $5. They're allowed to spend $5 on us, and it can't be for using them. It's really just to get our business into like marketing dollars. They can't just hand us money for using them. Broker or brokerage firm must first disclose in writing such compensation to whomever the broker or brokerage firm is referring at the time of making such referral. Okay, cool. So let's say this. Let's say that there's a roofer, because that's commonly where I see this. The roofer says, hey, Charles, if you send me any of your clients, I will give you $50. Cool. Perfectly legal. But here's the thing. If I'm talking to my buyers or my sellers, I'm saying, hey, I have a great roofer that you should be talking to. I have to let them know that that roofer, not only are they great, but they're giving me $50. Because here's the thing. If I have roofer A and roofer A is giving me $50 and roofer B, maybe the same caliber, not giving me $50, there might be a conflict of interest here. Who knows if roofer A is better or worse? We just know there's $50 attached to it. So at the time of making that referral, you actually have to disclose in writing, hey, Mr. and Mrs. Seller, hey, Mr. and Mrs. Buyer, when you use this company, they're going to give me money. Perfectly legal. It just has to be given in writing at the time. And the existence of an affiliated business arrangement, also known as an ABA, to the consumer that they are referring at or prior to the time the referral is made, this disclosure must comply with RESPA. So this is saying this. Let's say that you own that roofing company. All right. So it's not a $50 referral. You're making thousands of dollars off of this deal. Perfectly legal. You can have as many businesses as you want that touch real estate, and you can refer people all day long. Perfectly legal. You just have to make sure that firstly, you're registered with the Colorado Real Estate Commission as owning that business, because you're going to be tying in business to real estate. And the second thing is you have to hand it in writing, like, hey, Mr. and Mrs. Buyer, again, I own this company. Here it is. If you use them, we are great. And I'm going to be making money on the side. You have to just disclose all this. In the grand scheme of things, guys, it's all about disclosure. We have to disclose everything. Speaking of disclosure, we have disclosure of conflict of interest or license status. Brokerage firms and brokers have a continuing duty to disclose in writing any known conflict of interest that may arise in the course of any real estate transaction. If a broker sells, buys, or leases real property on the broker's own account, such broker must disclose in the contracting instrument or in a separate concurrent writing that the broker is a licensed broker, and a brokerage firm or broker engaged in property management services has a duty to disclose in writing any known conflict of interest that may arise in the selection or use of a business or vendor that provides services applicable to lease transactions, including property maintenance. The brokerage firm or broker is required to disclose any ownership, financial, or familiar interest associated with the selection or use of a particular business or vendor. Okay, cool. So, like, we're looking at this. This sounds like the ABA or the RESPA, right? Like, when I'm looking at C, I think of this. Cool. I have a family member that owns that roofing company. Perfectly legal for me to say, hey, use this roofing company. They are fantastic. Also, it's my cousin. Perfectly legal. We can do that. But with property management, they have to know, even if we're the ones that are, scheduling all the work done, if we're handing over those fees, the fee has to be disclosed that, hey, we have an interest. That'd be a conflict of interest if we did it. The second one, right? If we go look at B, we just know that we have to do that, right? When we're going through and we're buying and selling real estate, which is pretty cool, guys. Like when we're going through and thinking about this, you have the ability, if you buy a house, to collect the commission. And when you go to sell a house, you don't need to use a real estate agent. So you get to save the commission. We just have to make sure that we're disclosing it, right? We have an unfair advantage as a real estate agent to the general public. And remember, the rules are in place to protect the public from us. So we must disclose. And then just the continuing duty, any known conflicts that pop up, we just have to make sure that we're going through disclosure, disclosure, disclosure. Upon suspension, revocation, expiration, or transfer to an inactive status of a license, the broker or brokerage firm is responsible for immediate compliance with the following. All right. So, and this is if you're an associate broker, you have to cease all activities that require a license. You have to inform your employing broker of the change of your license status. You have to stop all your advertising. And you have to inform all of your consumers about what is happening and actually what that means for them. All right. So be thinking about this. You go through and you inactivate your license. Transferring license isn't a huge deal like that. That's pretty simple. But when we're going through, let's say that you get in trouble, your license gets suspended. Let's say your managing broker's license gets suspended. That automatically turns your license to suspended as well. So when any of that stuff happens, you don't have a license anymore. All the things that we know that you have to have a license to do, right? Buy and sell, lease, advertise that we're a real estate agent, negotiate contracts, all that stuff has to stop immediately. And we must disclose it to our clients. The next section in here is this handling of documents. Both a broker and a brokerage firm must retain transaction files for a transaction for a period of 4 years, beginning from the consummation date of the transaction or the expiration date of any listing contracts that do not consummate. Required docs in a transaction file are designated in the commission's transaction file checklist and may be found on the division website. Cool. So you're not going to be quizzed on which files you have to keep. And all the files have to be held for 4 years from the day that they're completed or the day that the contract ends. Remember that all of our contracts have a definite start date and a definite end date. And so if we do any deal in between that time, that's the time that we're starting, or at the expiration of our contract is what this is going forward and saying. Brokers and brokerage firms must retain and produce for inspection by the commission any documents on record as may be reasonably necessary for investigation or audit in the enforcement of commission statutes and these rules. Failure to submit such documents or records within the time set by the commission and its notification will be grounds for disciplinary action unless the commission has granted an extension. All right, cool. So we know this. If the commission investigates us, it's going to be in writing. 10 out of 10 times. I know that when we're going through studying, it says if they get a written investigation, then they are going to submit the investigation over to you and that you have to respond in writing. Very true. And guess what? This is the thing. The commission's never going to call you and say, hey, we got this. Please send us over the info. They're going to email you. The email is going to say what they're looking for. This is typically the stuff, right? And so if you're getting investigated really for any reason, you're producing paperwork. And so the paperwork, most of the time it's around your continuing education. Remember that we have to have 24 hours of continuing education every 3 years, test question. And when we're looking through, if they say, hey, prove it, we're sending them our certificates in writing. And so, same thing here. If someone says that you did something and the commission has to investigate it, you have to submit your paperwork to them. And this is what it's going to say. They're going to say, like, hey, someone said that you were representing them in property management and you did this. Prove that you didn't. Well, that's easy to prove. Like, here's all my documentation, right? Like, here's all of our contracts. This is what we did. Here's the contract to buy and sell. Here's the exclusive right. Here's all the provisions that I put in there, and you send it off. And it's pretty much as simple as that. And you write, like, this is your account of what happened. But this is a big piece of it. So this is why we have to maintain these records, because if you get a commission complaint, they look through, and I can tell you from experience, when agents inside my brokerage get these investigations, we have to send off records, and typically it's like three. They're like, send us the last three transaction files that you did. So the practice of law, we know in the state of Colorado we have the right to practice limited law, fill in the blank contracts, because Conway Bogue, also a test question. Brokers are not permitted to give advice on exceptions to title, as such conduct would constitute the unauthorized practice of law. Brokers must recommend before the applicable deadlines that consumers should examine all title exceptions and encourage consumers to seek guidance from a licensed attorney. Guys, this is so important. And you're going to get test questions around this. And here's the thing. In our contracts, and I know that no one's really dove deep into these, but in our contracts right now, it actually says it twice. In the very beginning, it says, this document has important legal consequences. Talk to a lawyer. And then in the body of our contracts, it says, these documents have important legal consequences. Talk to a lawyer. And so when we're going through this, when we're talking about title, that's well beyond our expertise. And that's why we hire out, the title company. We get the abstract, the abstractor, right? The attorney's opinion, the Torrens certificate, right? All those different things are what's happening, because we don't have the expertise to be going through that. So if something's popping up and your consumer says, hey, what do you think of this? Well, I think that we might need to get an attorney involved if you have any questions, right? So that's what we need to do. That's well beyond us. When we're talking about brokers are prohibited from drafting a contract document that would reflect the terms. So here's the thing. Conway Bogue, Rule F. All right. So Rule F means standard and approved forms. We have the right to fill in the blank contracts on standard and approved forms. Now, if we're looking at this, lease options, lease purchase agreements, and installment land contract transactions, they are to an extent that would exceed our level of competency and is a matter requiring the expertise and advice of an attorney. Additionally, such behavior may be construed as the unauthorized practice of law by the broker and subject to civil penalties. The contracts for these transactions should not be prepared by the broker. Rather, the document should be drafted by a licensed Colorado attorney engaged for this specific transaction. Cool. So this is saying this. Not only is the commission going to get you, right? Because this is the thing, that would be the unauthorized practice of law. And because of Rule F, this is not a standard and approved form. So there is nothing out there. So we can't draft that document. We can't do it. It's saying that the commission's probably going to come down on us. And if something goes wrong, we're going to get sued by our clients. That's what that does. Civil penalties means you're going to get sued on top of that. And here's the thing, guys. If we break the law, our E&O insurance does not cover it. So our E&O insurance only covers in the scope of our work. So this is saying, like, you're going to be exposed. Not only are you going to probably lose your license, if not, hit some other fines and stuff by the commission, your clients could sue you, and there is no protection from that. Unlicensed personal assistants. So this thing's huge, right? As I look through it, this is directly from the Colorado Real Estate Manual. Like this is, 1 through 14, everything. And so when we have an unlicensed personal assistant, the licensee law prohibits unlicensed persons from performing a real estate brokerage service, which includes negotiating the sale, exchange, or lease of real property on behalf of another. An unlicensed personal assistant may do the following. So if we're looking at this thing, complete forms prepared for and as directed by a broker. And so when we're looking at this doesn't mean that they can write a contract. Okay. Like, do not read, they can write a contract. If you tell them word for word what they're allowed to do, they can do it, but then you have to double check it. So you can say, yes, write this contract just like this for me. And then I am going to review it. Distribute pre-printed objective information prepared by the broker. Okay. Perform clerical duties. If authorized by the seller or listing broker, provide access to a property, and including showing or open houses. I actually think you're getting a test question around number 4. I think that if you get a test question around unlicensed personal assistants, I think the answer is going to be lying in number 4, that a unlicensed personal assistant can show a house with the seller's permission, of course, like it has to come from the seller. But I think that's going to be your test question. That's going to be the answer. Deliver paperwork to other brokers, complete administrative tasks, send out disclosure documents to the party, order title commitments, collect due diligence docs, review the entire transaction file, deliver paperwork, prepare market analysis on behalf of the broker. But again, it has to be approved and submitted by the broker. Collect the receipt of earnest money, schedule property repairs. Again, I don't think you're going to need to know a lot of this. I actually think it's going to be number 4. I think number 4 in this section is your test question. It's going to say, like, which out of all these can the unlicensed personal assistant do with the seller's permission? And it's they can do a showing or go to an open house. Number 4 is going to be your answer. Sign crossing. All right. So when we think about sign crossing, guys, I really just want you to picture a sign and you walking past it, right? Like you see a sign, you're like, cool. Like I know this person's looking to sell their home. It could be on the buy side too. I get that. Yet, you know that they are interested in selling their home and that they probably have an agency agreement. So brokers will not negotiate a listing contract directly with a consumer for compensation from said consumer if such broker knows the consumer has an unexpired listing contract with another brokerage firm. All right. With an exclusive right. Okay. So with this being said, it's again, you see that sign, you're like, cool. I'm going to go knock on this dude's door because I know that they're interested in selling their house. That's against the law. All right. That's called sign crossing. You were literally crossing the sign to go knock on the door to say, hey, I noticed that you're looking to sell your house, and the person that's listing it obviously doesn't know what they're doing because I've walked past this house for 2-3 weeks now and it's still on the market. Totally against the law. However, if that person calls you, like you're their neighbor, and they're like, "Hey, Charles, listen, my house has been listed for like 3 weeks, and my agent's just not doing their job, and I would like to have a conversation with you about how you can help me in the future." All right. So here's the thing. If you get that phone call, you're allowed to meet with that client. All right. You're allowed to meet with them. You're even allowed to sign agency documents. You're allowed to sign the exclusive right. And that exclusive right has to start the day that the current contract ends. All right. We're not allowed to be concurrent, right? That's a conflict of interest. Like a bunch of bad stuff happens there, mostly for our consumer because they'd be getting charged a lot of compensation at that point. So you get a phone call. They say, hey, my agent is not doing their job. I want you to represent me. And you're like, cool, you should have called me to begin with, yet I would love to help you. You can sign an agreement that day to take place on the day that the current contract ends. That's the rules around this thing. And if they ask you, well, hey, how do I get out of this contract? You can't help them with that because that would be law. All right. That would be the unauthorized practice of law. We can't go through and say, how do you break a contract? You may or may not know the rules on how to do it, yet we're not giving that information out. So, sign crossing. You can't go knock on the door, but they could call you. And if they call you, you can negotiate the contract to take place when the current one ends. All right, we're shifting gears. So we're in the brokerage relationship side of things. And again, this is 11 items. So we're talking again, this is 22 items in totality between these two subjects. So this is another 30%. It's actually like 29 point something, but we're going to round up. So we're looking at this thing. And first and foremost, we know that brokerage relationships must be in writing. All right. So we have to give these disclosures because this is what this is. This is a disclosure. These disclosures must be made in writing. And it says written disclosure must be made to a consumer prior to eliciting or discussing confidential information from a consumer for real estate brokerage services. So, what this is saying is you're typically a seller, right? You're representing the listing in this situation. You are representing the other party in a transaction, right? So when my mind goes to this kind of topic, I think of myself at an open house. This is typically where I'm going to probably experience this issue. I'm in an open house. I represent the listing, I represent the seller as an agent. All right. So put yourself in that situation. That's where you're at. It says such activities do not include primary conversations from preliminary conversations or small talk concerning price range, location, property styles, responding to general factual questions from a potential customer concerning properties which have been advertised for sale or lease. So again, it's Sunday and we're doing an open house. All right. So Sunday, we're doing an open house. We represent the seller, and someone walks in off the street and they say, hello, right? Like you're having a conversation. You know, what brings you in today? And they're like, I saw the open house sign. I followed all the open house signs into your home. And you're like, cool. And they're like, how much is this home? It's $600,000. Perfectly legal. Awesome. What kind of house is it? Well, it's a 3 bedroom, 2 bath, 2,000 square feet. Perfectly legal. They say, I need to be in a home in the next month because my lease is ending. Hold the front door. Like we got to time out. We have to stop it immediately because that's no longer preliminary conversation or small talk. All right. So that is a situation where we are finding out motivating factors. When someone gives us their motivating factors, what do we have to do with that when we represent the other side, right? If I represent the seller as an agent, I have a fiduciary responsibility to get them the most amount of money and help them win to put their needs above mine. So what that looks like is if someone tells me that they're going to be out on the street in 30 days and they love this house and they'd be willing to spend $100,000 over asking, you know what I have to do with that info? I have to give it to my seller. Well, now we have an issue at this point because this buyer that walked in may think that I could have helped them in some kind of capacity, and we're going to be stepping in it at that point, right? This is an issue. So someone walks in and you're having small talk. You do not to hand a brokerage relationship disclosure. Like you don't have to hand anything over to them. Yet when they start giving small talk, that's when you have to pump the brakes. And this piece of paper, that's all it is. It's a disclosure. It's not a contract. They don't even have to sign it. We know that they don't have to sign it. They don't want to sign it. You put did not sign and you give them a copy. Probably a test question. And with that being said, this brokerage disclosure just says this: I'm an agent for the seller. This is how I can help you, right? And it's going to say you might be a transaction broker. So could you help them in a transaction broker kind of relationship? Or could you help them as a customer? And it says, guys, we know as a customer, like they don't get a whole lot from us. We'll handle some paperwork. But that's really about it. So we actually have to show them what the relationship that we have and how we can assist them if we can assist them. That's the purpose of this brokerage disclosure. So let's say that we are in a transaction brokerage relationship with the seller. All right. We know in the state of Colorado that we could also be in a transaction brokerage relationship with the buyer, right? We can be with both parties as a transaction broker. That is not dual agency. Dual agency in Colorado is illegal. Yet we do have this mechanism called transaction broker. Transaction broker, you're a referee. We're going to talk about it here in a second. So we're not going to dive deep into it yet. And what this means is if we are traveling from an agent relationship to a transaction broker relationship, we have to do a change of status form. The commission has given us this status form. And what it is it says, hey, I'm no longer your agent. I am a transaction broker for the transaction, right? Agency, we have a fiduciary relationship. We are there to fight and to help our clients win. As a transaction broker, we're a referee, we're a neutral. And so we have to let them know that that change occurs. Now, here's the thing. Your client is giving you permission to go into a change of status in your exclusive right. So when you're doing your agency agreement, they know if you have the ability to do this. All right. This isn't just something where you're switching it on them and like just, halfway through a transaction and you finally get a deal and the buyer comes through and you're like, hey, seller, just want to let you know that I'm no longer your fiduciary and I'm going to go help the buyer as well. Good luck. That's not this. You've already had this conversation up front with them and they've given you permission to do this. If they don't want you to do this, there's a checkbox that says no, 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 no. You're going to be my agent through this whole thing. You are not going to be a transaction broker ever. But yet, if they do give you permission and this opportunity does arise, and it does not arise often, that you have to immediately give this change of status when you are going to switch. So let's talk about transaction brokerage a little bit. A consumer may enter into either a transaction broker relationship or an agency relationship with a broker for any type of real estate transaction. Now, here's the thing. We already talked about the office policy. So your office policy is going to let you know if you can or you can't. There's going to be brokerages that say you can't be a transaction broker in a single deal, right? There's going to be brokerages that say, you know what, we actually think it's not in our best interest for you to be an agent in a deal. So you always have to be transaction broker. So while the customer, the consumer gets to decide in the grand scheme of things, if it's not in your office policy, you can't do it to begin with. So you can be in a transaction broker or an agency relationship. And our exclusive right, it lists both of them. And so you check the box how you're going to help someone. The fundamental differences between a single agent and a transaction brokerage relationship is that a single agent is an advocate with fiduciary duties. That word fiduciary, guys, is only for agency. All right. So you do not owe fiduciary responsibilities to a customer, to a third party, to anyone that you're representing in a transaction brokerage relationship. Fiduciary points to agent all day long on your test. And it says a transaction broker remains neutral, is not an advocate. You're a referee. You're a paper pusher. You represent the transaction. You do not represent anybody. Yes, at some point you may have represented a buyer and a seller. And this is typically where I see this come together, right? I represent the seller over here. One of my buddies wants to buy a house and I have an agency agreement with them. Agency agreement with both parties. And so my buddy says, hey, you know what? I saw 123 Main Street and I see that you're the listing agent. I would be very interested in looking at that house. Okay, cool. So I'm an agent for both. No conflict of interest. My buddy says, hey, I want to write on that home. Now we have a conflict of interest, right? Now we're like change of status, transaction broker. We're dropping down from agency to transaction broker. And now you are not a fiduciary for anybody. You're a paper pusher. You're Switzerland. You're a referee. And we drop down into that transaction broker relationship. And it does say, however, the commission recognizes that in some instances, a buyer or tenant may not immediately execute a written listing contract. In those situations, the broker will function as a transaction broker. Cool. So, guys, our default in the state of Colorado is transaction broker. All right. So, if you do not have an agreement in writing, your default a transaction broker. So, someone gives you a call. Let's go back to your buddy, right? Your buddy gives you a call and they say, hey, I don't know if you knew this, but I was actually been looking at Zillow for the last couple months, and I saw a house that I'm really interested in, and I thought of you immediately. And you're like, "That is awesome! I super appreciate you thinking about me." They're like, "Well, I want to go look at that house today," and you're like, "Cool, I have free time. Let's go look." You jump in the car, you go look at the house. You don't have an agency agreement in place. By default, you're a transaction broker. It means you don't have fiduciary responsibilities. You're not an advocate. You can't be giving advice. You can't be doing any of that stuff. Pretty much you're a key turner in that situation. You're neutral. You're a key turner. Now, on our contracts, you can be a transaction broker or an agent through our exclusive right. And that's pretty much the standard contract that we use in Colorado is the exclusive right. Now, in that exclusive right, again, transaction broker agent, you can be a transaction broker without the piece of paper or with the piece of paper. You cannot be an agent without the piece of paper. An agency relationship must be in writing. So, for you to be a agent for a client, right? Because client and agent, you have to have an agreement in writing. So here it is. Single agent. And again, single agent, it's agency, which means there's a fiduciary relationship. I pulled this directly out of our contract. All right. So you guys are looking at verbiage from the Colorado contract, the exclusive right. And it says additional duties of the seller's agent. So we're looking at the seller's agent exclusive right to start. If the seller agency box at the top of page 1 is checked, the broker is a seller's agent. Remember, if the box isn't checked, you're a transaction broker. And these are your duties. You're promoting the interest of the seller with the utmost good faith, loyalty, and fidelity. You are seeking a price and terms that are set forth in the seller listing contract. And you're going to counsel the seller as to any material benefit or risk of a transaction that are actually known by the broker. Okay, cool. So for the seller, if I'm an agent, this is what I have to do if I have the agency box checked. I have an agreement in place. We have checked agency. This is what I have to do for my seller. Now, on the buyer side, same thing. It says additional duties of a buyer's agent. If the buyer agency box of the top of page 1 is checked, broker is a buyer's agent with the following additional duties: promoting the interests of a buyer with the utmost good faith, loyalty, and fidelity, seeking a price and terms that are acceptable to the buyer, and counseling the buyer as to any material benefits or risks of a transaction that are actually known by the broker. So by default, we're transaction broker. All right, whether we have the document signed or not signed. If we have the document signed, we can actually go into the agency section and check it off. And then we owe these responsibilities. This is why we don't have dual agency in Colorado. There's other states that do. So on your exam, on the national side of things, you're going to get dual agency questions. You will. You're not going to get any dual agency questions in the Colorado section. If you do, the answer is illegal. I don't care what the questions or what the other answers are. If you get a question that says dual agency is, the answer is illegal. Just don't even read the other stuff. Just check it off and move on. If you're looking at this, and let's just look at number 2. All right. So we're looking at seeking a price. So seeking a price and terms that are set forth in the seller listing contract. So your seller says, I want $600,000 for your home, for my home. And you're like, cool, seller, I like it. So you put in the listing contract, because that's where you put that information. And then you're working with the buyer, and the buyer says, I want to buy that home for $550,000. How in the world do you navigate that as an agent, right? It says that I have to get that price for myself. It doesn't say I have to, right? But I have to fight for it. And then I have to fight for 550 for the buyer. There is no world where you can do that. That's why in Colorado we don't believe in dual agency. Like we know it's impossible, and it's black and white right there. It's actually blue and white on the screen, but that, I mean, you get what I'm saying, right? Like you actually, there is no possible way for you to actually promote the interest of both parties in the utmost good faith, loyalty, and fidelity without hurting the other one. That's why we go to a transaction broker where we're like, listen, I'm a referee. I'm not going to advise anybody. I am not going to counsel you in any way, shape, or form. But if you tell me that you want me to deliver something, I'll deliver it. I'll let you know the dates and deadlines as they come up. But that's the best I can do. And if you need any other advice, you have Google, you have a lawyer, you have your CPA, you have all the other advocates out there. That's where you're going to need to go. So, single agency, guys, fiduciary relationship. And this is what it looks like. Again, without that signed, without that piece of paper without that agency agreement signed, you are a transaction broker by default in the state of Colorado. And then we have designated brokers. All right. Designated broker means an employing broker or an employed broker who is designated in writing by an employing broker to serve as a single agent or transaction broker for a seller, landlord, buyer, or tenant in a real estate transaction. All right, cool. We read that. It's like, how does the employing broker designate the employing broker to be a designated broker? Well, here's the thing. The brokerage firm is the one doing the deals. All right. So the relationship is with the brokerage firm. And I think that's the biggest thing to keep in mind. It does not matter if this person that you have a relationship with called you off of a sign or you cold called them, you found them on a website somewhere. This was your best friend from high school. This is your significant other. This is yourself. The brokerage is the one with the relationship. And I know that sounds weird, but the brokerage relationship, that's where it is. The contracts with the brokerage, and the brokerage designates you, the agent, to be the designated broker for that client. It says designated broker does not include a real estate brokerage firm that consists of only one licensed natural person. Okay, cool. So we know that if there's only one person, they are a single person firm. They are a single person firm. They don't need to have an office policy. And there's no such thing as designated broker because they're the only person there. So who else could they possibly work for? The brokerage relationship established between the seller, landlord, buyer, or tenant and a designated broker, including the duties, obligations, responsibilities of that relationship, shall not extend to the employing broker nor towards any other broker employed or engaged by that employing broker who has not also been designated, and shall not extend to the firm, partnership, LLC, association, corporation, or any other entity that employs the broker. So here's the thing. You are the designated broker. Your managing broker, while yes, they're going to get sued if you get sued, and if the commission comes for them, there's going to be some things. Yet, with that all being said, the relationship does not extend to them as well. So you are the designated broker. You're the one that has the relationship because he or she designated you to be the designated broker. And so this is where it gets even more interesting. Let's say that this is the seller. You represent the seller as the designated broker, and your managing broker actually represents the buyer. Perfectly legal. This does not create dual agency. This is perfectly legal. It's so legal, and that the brokerage relationship so does not extend to your managing broker that your managing broker can even look over your paperwork and be your supervisor. And I know you're thinking, like, that's kind of weird. How in the world, where do you go get the training to be able to look at my paperwork and to sign off that it's good while negotiating against me. Perfectly legal. While we don't have dual agency, somehow this is legal in Colorado. I don't know what the special training looks like. I actually have gone through managing broker. I have my managing broker's license. I can tell you that there isn't any training around this. And it does not extend to them. So it does not create dual agency, which I actually think will be a test question. And so your managing broker can actually work on the other side of the deal and still supervise you through this, and there is no conflict of interest there. A real estate broker may have designated brokers working as single agents for a seller, buyer, or landlord or tenant in the same real estate transaction without creating dual agency for the employing broker, or any other broker employed or engaged by that employing broker. So all that just said was the first part that we just talked about. But the second part is this: you can have a colleague on the other side of the deal. So someone could represent the buyer, you could represent the seller, and that's still perfectly legal. There is no conflict of interest. This does not create dual agency. The designated brokerage relationship stops with you. So, your managing broker again could be looking at their paperwork and your paperwork. You could both be calling that managing broker and asking questions. Perfectly legal. So, as we're starting to wrap this up, this is 22 items of what you're going to see on your Colorado real estate exam. This is 1/3. So 1/3 is Colorado forms and contracts. Another third is these two sections right here. And again, like you can see the brokerage relationships one, like we talked about 4 slides, which is a big piece of it. And it really is just around disclosures and how you operate as an agent with fiduciary relationships versus a transaction broker as a referee. And then the other 11 could really come from any of the sections from A to I, right? I think you're going to see that unlicensed personal assistant one. I think you're going to see that as answer 4. Sign crossing is definitely going to talk about it. The practice of law, right? They're really going to talk about, can you write up a contract that doesn't exist? No, you can't. That's lawyer all day long. Handling of documents, 4 years. We know that. Disclosure of conflicts of interest. It's probably going to be more of a question around writing it into the contract or an additional piece of paper saying that you are a licensed real estate agent. Commissions, I really think it's going to be around settlement service providers and ABAs and how you're going to have to go forward and make sure it's in writing at the place before it happens. And it's perfectly legal. Perfectly legal. You just have to make sure it's in writing and that they understand. And then your brokerage administration, the office policy. I think you're going to get the office policy. You're also going to have to get the resides in Colorado. I think that's going to be absolutely a test question for you. And then advertising. I think that the advertising thing is really going to be along the lines of realty, realtor. Like you can't have any of those. It's probably going to say which one of these can you or can't you have. And just know that anything that makes you look bigger than what you truly are, group is fine, right? You can say group, you can say team, you can say any of that, but if you're like such and such LLC, not okay. Now, side note, real quick, practical application, not for your test. If you do have LLC or something, that's perfectly fine if it's in for your tax purposes only, right? Not your advertising, right? Like you go out and you create an LLC, an S corp, a something for tax purposes that's not consumer facing. Perfectly legal. I get that question every time when people get into real estate. But for advertising on your social profiles and everything, you can't have any information that looks like that could mislead the public.